Hi, everyone. Welcome to the first webinar in the 2024 Employment Webinar Series. I see that we still have some people joining, but we'll go ahead and kick it off just to make sure we get through all the material we have for you today. So today's webinar is DOL Update 2023 Changes Affecting Businesses in 2024. They'll largely focus on two significant rulemaking efforts from the Department of Labor in 2023 that will impact 2024. And before we get into the substantive material, I'm going to kick it over to my co-presenter, Kimberly, to introduce herself.
Hi, I'm Kimberly Richardson. I am an attorney in Conn Maciel Carey's OSHA and employment practices. I've been practicing, for almost 20 years now at firm, in the federal government, and in-house. I've done everything from high hazard and complex manufacturing organizations to your basic slips, trips, and falls. I really enjoy this work. And I'm happy to be joined here with one of our partners, Lindsay DeSalvo. And Lindsay, I'll kick it over to you.
Thanks, Kimberly. So as Kimberly said, my name is Lindsay DeSalvo, and I'm a partner at Conn Maciel Carey in both the firm's OSHA and labor and employment practice. And for purposes of our discussion today, I have been representing employers in all aspects of the employer-employee relationship for around 10 years now. And a good amount of my practice has involved wage and hour issues and wage and hour disputes. And as part of that, I also have a lot of experience reviewing employee classifications as either independent contractors or any of the white collar exemptions, as well as policies, procedures related to wage and hour issues like calculating time, setting job descriptions to sort of encompass some of these issues, and review of those as well, and guidance and advice related to those issues. So with that quick introduction, we will jump right into our content for today's webinar. And Kimberly is going to talk us through the Department of Labor's new independent contractor rule.
Thank you, Lindsay. So on January 10th of 2024, the U.S. Department of Labor issued its long-awaited final rule, revising the department's guidance on how to determine whether or not a worker is classified as an employee or an independent contractor under the Fair Labor Standards Act. And for grounding purposes, the Fair Labor Standards Act, or what we call FLSA, establishes certain wage and hour rights for employees, requires covered employees to pay their non-exempt employees at least the federal minimum wage for every hour worked, and overtime pay for every hour worked over 40 hours a week. It mandates certain record-keeping rules as well. However, those minimum wage and record-keeping rules do not apply to independent contractors. And as a result, employers sometimes wrestle with how to determine whether or not a worker is an employee or independent contractor. And the rule changes that I'm going to discuss today really are important because they not only express how the agency sees independent contractors, but also they inform the regulated community on how to properly classify those workers. Lindsay, if you can go back to the previous slide, please. Two more up, the one that has the blue boxes in it. Keep going back, keep going back towards the front. Yep, that one right there. Perfect. Thank you. So this is very important because there's been an evolution on the way contractors are classified. And over the last few years, the Department of Labor, or I might reference as the DOL during this presentation, has made the proper classification of independent contractors a priority. And they have expressed interest and that priority repeatedly because they have an interest in preventing employers from misclassifying workers. As I mentioned before, if you're an independent contractor, some of these wage and record-keeping protections do not apply to you. And it's also important for the regulated community to get it right because misclassified independent contractors can expose employers to significant potential liability. And so one of the reasons why employers wrestle with the classification of independent contractors is because the FLSA does not define the term independent contractor. There is a definition for your employee, but it's circular. Generally, an employee is any individual employed by the employer, and that definition is not informative whatsoever. It does say employ means to permit or to suffer to work. And what does that mean? Because that in itself is not very informative. Historically, the DOL has relied on informal guidance to provide information on what it really means to suffer or permit to work. And in 2021, under the Trump administration, the DOL issued more formal guidance. I'm sorry, they proposed it in 2020, and then in 2021, it was finalized. This was a 5-factor test that emphasized certain factors, such as the degree of control over the work and the worker's opportunity for profit and loss. We generally call this the 2021 independent contractor rule, or I may call this the core test, and then you'll see why momentarily. So that was in 2021, but also in 2021, a new administration took over. The Biden administration, when they took office in early 2021, they were faced with a new rule that had been finalized essentially under the previous administration. It was set to go into effect on March the 8th, I believe, 2021. And the Biden administration decided to delay the implementation of that rule. And then they subsequently tried to withdraw the rule. But that action was faced with challenges in court and litigation. That litigation is ongoing, and we'll talk about that a little bit more soon. But when this Biden administration was faced with these legal challenges, they decided to take a new approach. And essentially in 2022, they proposed a new 6-factor test that would go back to that previous informal guidance that was very similar to that previous informal guidance that was used prior to the 2021 independent contractor rule. And that's where we find ourselves now. That proposal that was originally put forth in 2022 is now a final rule, and it is set to go into effect soon. Next slide, please. Perfect. So this new independent contractor rule, and I say new, but again, it is very similar to what was used prior to that 2021 independent contractor rule. It was published, the final rule was published January 10th of this year. It is scheduled to take effect March 11th of this year. It rescinds that 2021 independent contractor rule, which some saw as being more friendly to industry, business, the regulated community, and it replaces it with a rule that looks at various factors differently. And some consider the new rule, the one that's issued just this year, to be more friendly to determining that people are more likely to be employees. And we'll talk a little bit about why that is. When the Department of Labor issued this new rule, they went to great lengths to talk about how this was really going back to the pre-existing interpretations, what we generally call as these economic realities tests. But it's important to know that this is an interpretive rule as opposed to a substantive rule. What that means is that this is strictly for the interpretation of employee-employee from the perspective of the agency. It informs the public of what the Department of Labor's view is of the law, but it is not binding regulations to which courts must defer. And so with that being said, it provides a lot of guidance to the regulated industry, but it still requires us to dig deep to make sure we're clear about what has changed. So let's compare and contrast the 2021 independent contractor rule with the 2024 contractor rule. And that's where we get to this core test. That 2021 independent contractor rule prescribed a 5-factor test. And that 5-factor test really had 2 core factors. And those 2 core factors carried more weight in the inquiry or the analysis. The 2 factors that were the core factors were the nature and degree of control of work and the worker's opportunity for profit and loss. And if these 2 factors point in the same direction towards independent contractors, more than likely, the determination was going to be this person was an independent contractor. Vice versa, if they pointed towards the person being an employee, more than likely that the entire determination was going to be that this person was an employee. The other three factors that were considered but had less weight were the amount of skill required to do the work, the degree of permanence of the working relationship between the worker and the potential employer, and whether the work is part of an integrated unit of production. So, what was wrong with this? What did the Biden administration think that was an issue with this? And they had an issue with the heavy weight on those two core factors. They believe that was inconsistent with the Fair Labor Standards Act, the text of the law, the historical interpretations, and existing judicial precedent. And they also believe that it lends itself to more misclassifications. And so for those reasons, the current administration believed it must be replaced. And that's where we find ourselves today. So what is that replacement? What is the 2024 rule? Whereas the 2021 rule was a 5-factor test with core factors, the 2024 rule is a 6-factor test. It establishes more of the economic realities test that looks at the totality of the factors. No 2 factors or single factors, no group of factors have more weight than the rest. And it reinstates this heavy emphasis on the worker's economic dependence on the employer. So what, again, I'll reiterate, what is the true economic reality of the relationship between the parties? So these factors are, and I'll kind of group them into kind of 2 groups because I think that there's a theme here. There's a theme that supports this view that the independent contractor should be more of an entrepreneur, or the relationship should be more entrepreneurial in nature. And so for the factors that really lends itself to that theme are the worker's opportunity for profit and loss, depending on managerial skills, investments made by the worker and the potential employer, the nature and degree of control of the employer has over the work performance of that worker, and the worker's skill and initiative. The 2 other factors are the extent to which the work performed is an integral part of the potential employer's business, not just a production unit, but the business, and the degree of permanence of the work relationship. As I said before, no single factor or group of factors is assigned a predetermined weight. This test, while it is a 6-factor test, it also lends itself for consideration of other factors that are not listed there. And so the agency is clear about that this is not necessarily the only factors that may be considered. You also don't have to check every single box to make a determination. This is not a ABC type test where you have to check and have so many boxes checked in order for you to make a determination that a worker is an independent contractor. You truly look at the totality of the circumstances. Now, we're going to talk about each of these factors independently, and it's important that we do so because there are some cautions here. So next slide, please. Let's get to the factor number 1, which is the opportunity for profit and loss depending on managerial skill. This factor analyzes whether the worker's business skills affect their economic success or failure. So some questions that you might ask are, can the worker hire their own workers? Do they rent their own office space? Do they meaningfully negotiate pay or charge for the work that they are providing? Can they accept or decline jobs? Can they choose the order or the time in which work is performed? Do they engage in marketing, advertising, or other efforts to expand their business or secure more work? And do they purchase their own materials or equipment? If there's no profit or loss opportunity, then this person may not be an independent contractor. Again, totality of the circumstances, this is just one factor. But that's the way that this particular factor is analyzed. But I will put some caution here. Merely working more hours or taking more fixed rate jobs does not necessarily indicate independent contractor status. You do not, because those 2 things, like just working more hours or taking more jobs, do not necessarily require the exercise of managerial skills that are required for this factors analysis. Next slide, please. Factor 2 is the investment made by the worker and the potential employer. Now, this factor analyzes the investments by the worker that are capital or entrepreneurial in nature. So what are the costs to the worker for the tools or the equipment to do the job? Are the costs unilaterally imposed by that potential employer? Do the worker's investments, are they designed to increase his or her ability to do more work, or different types of work, reduce their overall costs, extend their market reach? What about the cost incurred by the worker for the tools and equipment to perform the job? And that potential employer do they impose any unilateral costs on the worker? In other words, does this relationship look like the potential employer is supporting an independent business on a smaller scale? Or does this look like they're just supplementing their workforce? And the focus should be on whether the worker is making the types of investments that a business would, again, but maybe on a smaller scale. Next factor. Factor number 3 looks at the degree of the permanence of the work relationship. This analyzes the duration and the exclusivity of the work. Is it exclusive, indefinite, or a continuous working relationship? Because if it is, that may be evidence of an employee-employer relationship. Is it non-exclusive, sporadically based, or project-based work that's based on the worker being in business for him or herself and marketing their own services or labor to multiple entities? Because if that's the case, it may be evidence of an independent contractor status. Now, mind you, this is not just about duration. Seasonal, temporary, or short-term work is not necessarily indicative of a contractor status in and of itself, because it does not result or require independent business initiative. So work may be short in duration due to operational characteristics intrinsic to the business or industry. And for that reason, it's a broader analysis than just the duration. Next factor, please. The nature and degree of control the employer has over the work performed is factor number 4. This factor analyzes the potential employer's ability to control the performance and all economic aspects of the relationship. So some questions you might ask are, does the employer set the worker's schedule, price, or the rates? To what extent does the potential employer supervise or discipline the worker? To what extent does a potential employer impose restrictions on the worker's ability to perform work for others? So one note about supervision here. Now, this may be imposed through the use of technology like tracking or remote monitoring. It need not be in-person or direct supervision. This is important, particularly today, where it's not uncommon for people to work remotely. So mere remote work does not mean that there is no supervision. Another thing to note is that actions taken by a business to comply with specific laws or regulations are not necessarily indicative of control over the employee. If a law tells you you have to do something, that in and of itself is not control that's indicative of some type of employer-employee relationship. However, if you go above and beyond compliance for that specific law or regulation to serve your own compliance methods, safety, quality control, contractual needs, that sort of thing, that may be indicative of control for factor number 4. Next slide, please. Factor number 5 is the extent to which the work performed is an integral part of the potential employer's business. This analyzes whether the work is critical, necessary, or central to the business, not necessarily whether or not the worker is integral to that part of the business. So it's about the work being performed, not necessarily about this particular person. Factor number 6, please. And in the list of itemized factors, this is the last one. This is about the worker's skill or initiative. This analyzes whether the worker uses some type of specialized skills and taking business-like entrepreneurial initiative to advance their own independent business needs or desires. Now, caution that specialized skill alone is not sufficient in and of itself here. It must be used, that specialized skill must be used in connection with some type of business-like initiative. If that worker is dependent on the training from this potential employer, this factor might lean more towards an employer-employee relationship. Now, if this worker possesses specialized skills and demonstrates entrepreneurial judgment, then this may be more likely to be an independent contractor leaning factor. Now, again, I want to reiterate again, this is the totality of the circumstances. Not one of these factors alone is determinative in and of themselves. It is about looking at all of the factors. Next slide. Let's compare and contrast a little bit, just a high-level view of what the differences are between that 2021 independent contractor rule and the 2024 independent contractor rule. So just to recap, we are returning to the totality of the circumstances test, more of an economic reality test where no single factor or group of factors is assigned any predetermined weight. And we're returning to more factors. Actually, we're adding more factors. Instead of having 5, we now have 6 with the possibility of considering other issues that are not necessarily itemized. One of those additional factors is the inclusion of the investments made by the worker and the potential employee. It's continuing that entrepreneurial theme that we saw with all of the factors articulated by the Department of Labor. There's also some additional analysis under the control factor. So the control factor was seen in the previous 2021 test. It is in the 2024 test. However, there's more of a detailed discussion analyzing scheduling, supervision, price setting, and the ability to work for others. The 2024 test returns to the Department of Labor's longstanding consideration of whether or not the work is integral to the employer's business, rather than when it's whether it's exclusively a part of an integrated unit of production. The Department of Labor also provided additional context for some of the factors. And they admitted a provision from the 2021 independent contractor rule that minimized the relevance of an employer's reserved but unexercised rights to control a worker. Now, with this change in particular, there's significantly more nuance. And because of the nuance, it's going to require employers really to dig deep and understand how the Department of Labor is interpreting its own regulations and the Fair Labor Standards Act in general. And it may actually result in less definitive answers to questions you may have as you wrestle with independent contractor classifications. There also may be less clarity that comes from this change. And with less clarity and the priority set forth by the Department of Labor, there's going to be enforcement, which could result in more litigation. This is already a heavily litigated area by the Department of Labor, and so I would not be surprised to see more litigation as a result of more enforcement and confusion over the changes. Next slide, please. Now, previously I mentioned that this is scheduled to go into effect in March, but there are already challenges to these rules. Just days after the new rule was published, the previous suit that I referred to earlier when the Biden administration delayed and then tried to rescind the 2021 independent contractor rule, there's litigation now to lift the stay on that litigation, to move that litigation forward. A few days later, on the 16th of this month, a group of freelance writers and editors filed suit in the Northern District of Georgia seeking a preliminary injunction, trying to hold that this rule is unlawful. We also see rumblings from Senate Republicans who have indicated an intent to initiate a resolution to repeal the rule under the Congressional Review Act, but that's unlikely to be successful under this administration. Nevertheless, with all this being said, please stay tuned because this is not the end of the story here. It's too early to make predictions in terms of where some of this stuff is going, but it's important to highlight that there are challenges. So we anticipate that it will go into effect in March, but depending on how these challenges play out, we're not quite sure where this is going. So stay tuned. Stay alert, especially with regard to our blogs. We blog on this type of stuff, keeping the community updated on regulatory changes for not just labor and employment issues, but also health and safety issues. Now, with all of these changes and with the changes and the interpretive changes and the challenges to the regulations, what should employers do? Next slide. We've got some recommendations here for compliance, and we'll start with the ones that you see here on your slide. The first one, these are hygiene matters that are just good regardless of what the agency does. So the first one I want to highlight for you is memorializing the terms and conditions of an independent contractor relationship in the contract. So although courts have found that an employer-employee relationship may exist despite the lack of existence of agreement, it's so important to have an agreement in place. And that agreement should be signed by both the organization, the potential employer, and the independent contractor. And the contract should include specific acknowledgement that this person is going to be performing work as an independent contractor and not an employee. It is also important that the employer establish policies to direct control over how to direct control over independent contractors. Don't leave this to someone's gut. It's important that we provide guidance on how to do this properly. Management of employees by the company should be done with guidance and some guardrails. And making sure that your managers and supervisors are trained and aware of what these policies are and know where the landmines are so that they can then avoid them. Your independent contractor relationship should be established with fixed terms, limited duration relationships. The relationship should be explicit in terms of, especially if it's written, how long this is intended to last. In addition, interaction between employees and independent contractors should be minimized. This is important because the person's perception as they are performing work, the more that they're ingrained into the culture, the more they may believe themselves to be an employee. To the extent possible, consider including separate training, separate communications, exclusion from social events. This may require also communication so that people understand why you're doing what you're doing, that you're not just singling out somebody, that there's a reason, there's a method to your madness, so to speak. And also, independent contractors should not be provided the employee handbook or asked to abide by all the terms just like an employee would. There should be specific rules for those people, separate. And finally, review existing policies. It's important just in good, even if there weren't changes, just to periodically review your policies. Look at vacation, sick policies and other paid leave policies to make sure they don't cover independent contractors. And benefit plans should explicitly exclude independent contractors and temporary workers. Next slide. Just as a high level, some of the things that we at Conn Maciel can help as well on is looking at your independent contractors arrangements. What do your contracts actually look like? What does your process look like? Have you considered conducting a classification audit? Have you considered looking at your people, especially in light of the changes, to make sure you know what the nature excuse me, what the nature of the relationship may be in the eyes of the agency under their new interpretation. And finally, I'll highlight this again. I mentioned it before, but Again, this is an interpretive rule, which means it does not override other laws and regulations in this space. There are other acts, both federal and state, such as tax laws, state wage and hour laws, that have their own tests for independent contractor status. And you have to comply with all that are applicable to you. And with that being said, it's important to really understand to what rules you're subject and to make sure you are truly in compliance with all of those rules. And I believe that's all I have for independent contractors. I'll turn it over to you, Lindsay.
All right, thank you, Kimberly. Sorry about the confusion earlier with the slides. Hopefully we have that on track now. So the next big portion of our presentation is going to be reviewing the Department of Labor's proposed overtime rule. So for those of you that have been, following the evolution of the white collar exemptions over the last several years now, I think going back to almost when I started practicing, I think around 2013, 2014, is when this effort really ramped up to address the threshold salary levels for the white collar exemptions. So that has taken another turn, initiated last year. And so we're going to talk about that a little bit before we get into the specifics of the new proposed rule. We want to take a little time to just review, what the current overtime rules are and what those exemptions are that would be implicated by the recent effort to increase the threshold salary levels. So Kimberly mentioned this in the beginning of the presentation, but the Fair Labor Standards Act requires that employees receive overtime pay of at least 1.5 times their regular rate of pay for work in excess of 40 hours in a work week. And that is the federal standard. A lot of states have their own requirements, but they have to be at least at this level. So 1.5 times the regular rate of pay for all hours in excess of 40 hours per work week. That is the standard. But the Fair Labor Standards Act, or the FLSA, does have some exemptions to that requirement. And they are what we generally refer to as the broad bucket of white collar exemptions. So certain types of workers who are exempt from that overtime requirement based on the criteria that you see on this slide. So the first is that they be paid on a salary basis. And we'll talk a little bit about what that means, because it will be really important now as this rule progresses to make sure that these criteria are considered in the classification of your employees. So first, they have to be paid on a salary basis. Next, they have to be paid at least the designated minimum weekly salary. And that's what's potentially being changed, or there's an effort at least underway to change that again. And then finally, they have to perform certain duties. And we'll talk a little bit about what this means. There are 5 basic types of white collar exemptions. There's the executive exemption, administrative exemption, professional exemption, outside sales. And then the last one here is the computer related workers. So each of these has specific duties related to them that must be met in order for a worker to be classified under one of these exemptions. And we'll talk a little bit about that. And that will be different depending on which bucket the individual worker falls into. But the salary threshold would apply the same to all 5 of these characterizations. And that's what, again, will be implicated by the rulemaking effort. So step 1, determining whether they are actually paid on a salary basis. And there's 2 buckets that employees could fall into at this initial step of the evaluation. The first is that weekly compensation is set at the threshold level or above that the Department of Labor provides. And that weekly compensation cannot be subject to changes based on quantity or quality of work. So this is your employees who have a set salary. They're paid on a weekly basis. I mean, they might be paid on a bi-weekly or every 2 weeks bi-weekly basis, but on a weekly basis, they earn a certain set level. And that level is not implicated or changed at all because of the quantity or quality of the work. And you can see this question arise sometimes where you have an employee who maybe takes a couple hours off at the end of the day because they need to go do something, or they get sick or something like that. And if it's, one day they take off a couple hours at the end of the day, their weekly pay can't be docked because of the fact that they took off that couple of hours at the end of one day during that week. That would indicate change to their salary based on the quantity of work. And then as to quality, if there is some issue with their work, if they're not performing to the level the employer expects, or they're missing deadlines, things like that, those things also cannot impact that set salary that they receive. The other consideration in this context is employees who fall into one of these buckets can be paid on an hourly, daily, or shift basis, but there are certain requirements that must be met for that to be permitted under the law, and for them to still be recognized as receiving a salary to qualify into one of these white collar exemptions. And this just gives a little bit more detail around that. I won't spend too much time on this, but the idea here is that there needs to be a reasonable relationship between the quantity that the employee is promised and the quantity that they actually make based on their hourly, shift, or daily pay. And that generally, the Department of Labor has said that the ratio of their usual earnings has to be about a 1 to 1.5 ratio to the guaranteed payment that they are actually guaranteed per week, or based on their set salary. So that is a little bit tricky. That can be a bit confusing, but I think the most important thing to get from this is that they can be paid on an hourly, daily, or shift rate basis, but there are certain criteria that must be met, and they certainly do still need to be earning that required threshold level, which is now set at $684 a week, to be able to qualify as being paid on a salary basis and meet the white collar exemption. So the second step is really just, that they receive the salary threshold level as prescribed by the Department of Labor. And we'll talk about that a little bit related to the ongoing rulemaking effort. And then the last step is the duties test. And this is where we generally sort of spend the most time from a legal perspective, is evaluating whether the nature of the employee's job responsibilities would qualify them for any of those 5 categories of the white collar exemption. There is also this additional bucket, which is the highly compensated employee. That is part of the white collar exemptions as well. An employee who is considered a highly compensated employee should make, currently, based on the current rule, should make at least $107,432 per year. And what this means is that they have to make at least the minimum threshold level of $684 a week for their salary. And then on top of that, whatever the additional money they can make on top of that amount equals or exceeds this $107,432 to qualify them as a highly compensated employee. And actually, as a highly compensated employee, there also are specific duties that must be considered to ensure that they are properly classified as a highly compensated employee. And those 3 duties specifically are to manage the enterprise, direct employees, and hire and fire. So these are really sort of your top level executives, and there is a minimum salary threshold set for them as well. So this is just an example of a couple of the categories of white collar exemption. that show the different duties that should be considered as part of this duties test analysis. And we have here just provided the executive and administrative white collar exemptions. For the executive, an employer would have to look at whether their primary duty is the management of the enterprise, or a customarily recognized department or subdivision. So your executives are your management level employees. So it's evaluating, whether their primary duty is management. And then as part of that, whether they customarily and regularly direct the work of 2 or more full-time employees. And then it talks a little bit more about what that means. What does it look like to actually customarily and regularly direct the work of 2 or more full-time employees? And then the administrative exemption, and part of the reason that we always include this one in the example around this discussion is because this is probably the biggest area where we have questions from employers about whether someone would qualify under the administrative exemption. Because it is, I think, a little bit broader. It's not so, I think, straightforward in the primary duty analysis, because the primary duty has to be the performance of office work directly related to the management or general business operations. And specifically, that primary duty requires the exercise of discretion and independent judgment. So there's, a lot of discussion around what that means. What does it mean to have an exercise discretion and independent judgment? And that's where, questions can arise to whether someone has been properly classified as an administrative employee. And so you have to go through all 3 steps of that analysis to determine whether someone is properly classified. And that sort of leads into, what we really want to focus on in this discussion is what is this new effort that the Department of Labor is undergoing related to the white collar exemptions. So again, as I said, this has been an effort that's been ongoing for a while. Back in 2019, the administration and the Department of Labor set a specific salary threshold, a new salary threshold that actually took effect. And that's the one that's in effect right now. And in 2019, that salary threshold was set at $35,568 per year, or $684 per week. So that's the 684 that I've referenced a couple times throughout that initial discussion. And then the highly compensated employee level, again, is that $107,432,000 level. And the idea being that anyone classified within one of those white collar exemptions is making at least that amount of money to be considered, at the level that the Department of Labor at least has determined is appropriate to be exempt from that overtime requirement that I referenced in the beginning. And this was actually this level that is currently in place and was set back in 2019. It is significantly lower than what the Department of Labor attempted to initially do with the salary threshold level, which was raise it to $47,476 per year, or $913 per week. That was the level that it was raised to initially in 2016, when the Department of Labor promulgated its final rule at that time. But that rule never had a chance to take effect because it was challenged, and the federal court actually determined that the Department of Labor exceeded its authority in setting the levels, per the court's findings, so high, because what that did was it effectively rendered the duties portion of that test, so that last step that I just talked about, meaningless. The court determined that if the salary was going to be set at that level, then there wouldn't really be much of a point for the duties test. It would disqualify so many employees. And so as a result, then in 2019, the Department of Labor passed the current levels that are in play right now. So what this new effort is another attempt by the Department of Labor to potentially increase those levels again. So on September 8th, the Department of Labor did issue a notice of proposed rulemaking to update those salary threshold levels. And that's really the focus of the rule. The rule does not change anything about the current duties test. It's really focused on these salary thresholds. At that time, they provided a 60-day public comment period. So that comment period closed on November 7th. And that was the time during which interested parties could submit comments to the Department of Labor and, give their impressions, their, understanding, their real lived experience related to how this rule could impact them if it goes into effect as proposed by the Department of Labor. So now we are in the stage where the Department of Labor is evaluating those comments to determine whether it will make any changes to the rule that it proposed back in September. And that period can be quite extensive. I believe there were around 33 comments submitted as part of the public comment period. It's a lot of comments to go through. So it could take the Department of Labor quite a bit of time to get through them. And they need to not only read the comments, but they actually have to respond to the comments in the final rule that they actually promulgate to show how those comments have been considered. So that can be a time-consuming process. But we do think there will be a real push from the agency to get a final rule out this year. And so we think that there is a strong likelihood that they will push to get something out this year. And not only that they'll push to get it out this year, but that they will push to have it go into effect this year. So when the final rule is issued, it will include an effective date. And we think the Department of Labor is likely to really try to get an effective date this year to go into effect, particularly based on the fact that this is an election year and it's unclear, what administration will be in place at the end of it. So what specifically is the Department of Labor proposing in this new rule? So like I said, the real thrust of this rule is to increase the salary threshold for those employees that can fall into one of the white collar exemptions. And what they are proposing currently in the proposed rule is increasing the weekly salary level to $1,059 per week. And then that would equate to $55,068 per year. So any worker who is going to be classified in one of these white collar exemptions would have to make at least that salary level or above that salary level. And then as to the highly compensated employee threshold, they have proposed to raise that level to $143,988 per year. A significant and important thing I think to point out in the rule is that the Department of Labor has also proposed increasing those salary thresholds automatically every 3 years. So that is something that they have attempted to do in the past, is to set as part of the rule automatic increases. That has not gone into effect as of yet. But what they would propose here is that the salary thresholds are updated every 3 years, and it would be based on the 35th percentile of weekly earnings of full-time non-hourly workers in the lowest wage census region. So it would be based on the data at the time of the increase, set at around the 35th percentile for the threshold levels for those white collar exemptions, like the executive, administrative, and so on, those exemptions. And then I believe the highly compensated employee threshold would be set at the 85th percentile nationally at that 3-year mark. So that is definitely important. That would have significant impact on employers in the sense that, this salary threshold is not going to be static. So it would likely require reconsideration at that 3-year point to determine whether there needs to be any additional changes made to someone's classification based on the increase in the salary threshold level. So what are some of the implications of the revisions to the salary threshold level? I think one of the main results, and something that we have focused on in the comments that we've submitted in the past, related to these rulemaking efforts is it would result in significant increased costs to employers, because there would be a lot of employees that would likely need to be reclassified to employee status as opposed to falling into the white collar exemption. And this would be a cost not only to the extent that, there would be more overtime pay owed potentially, if those employees are still permitted to work additional hours beyond 40 in a work week after they've been reclassified, but also certainly the costs associated with reclassifying employees, generally doing that analysis, making changes to policies and procedures as necessary to account for the new classifications and how employees are going to be classified. It would also, as I have implicated, require employers to evaluate and reclassify employees as necessary. So, there will be many employers will have employees who are right on the line of the salary increase. So potentially you could have employees, if they are close to making whatever amount the Department of Labor ultimately sets as the new salary threshold, then potentially they could just have a slight increase in their pay, and that could, keep them within their exempt status. But for many employees who, are closer to the current level of $35,000, increasing their pay up to $55,000 would be a significant cost to employers, and a lot of employers probably wouldn't be able to do that. And so then it's reclassifying those employees and figuring out how to, make that work in the current work structure. And then finally, as I mentioned as well, reconsideration of policies regulating overtime and overtime tracking systems. If all of a sudden you have a lot more employees who could be eligible for overtime, this may require revamping a tracking system or really adopting a stricter tracking system, whatever is necessary to ensure that the hours of those employees are effectively tracked. And then certainly policies might need to change to really limit who is able to work overtime hours, to sort of rein in some of those costs associated with having to reclassify employees so that they are eligible for overtime. Just real quick, as I already discussed the effort from the Department of Labor back in 2016, and the fact that the salary level had been raised at that time to $47,476. And that a federal court did determine that exceeded their authority because it made the duties test meaningless in practice. And so at that time, the Department of Labor did go ahead and, they did raise the threshold, but they raised it significantly less. And that's what we have in place right now. There was recently also a federal decision that determined that the Department of Labor's authority to set a salary threshold, that it confirmed that authority, that the court determined that the Department of Labor does have the authority to set a salary threshold level. That was challenged, whether they even had the authority to do so. But the court determined that they had that authority under the current standard of Chevron deference. And the Department of Labor's interpretation of the FLSA to give it that authority is reasonable under that current Chevron deference standard. And notably, the Chevron case has been challenged. It was just recently argued, I think last week, before the Supreme Court, that they should change that level of deference, that the interpretation of these standards should really fall to the courts. And so the current challenge what they've asked is that Chevron deference no longer be the standard. And there's certainly favor among many justices in the Supreme Court to take that step. So that'll be interesting to see what happens with that case, and that could ultimately impact the determination of whether the Department of Labor has authority to do this. But they have that authority right now, and that's the authority that they're operating under in this current rulemaking effort. So I'll just kind of go through this really quick. Just some of the things that employers can start thinking about, start evaluating as the proposed rulemaking effort continues before a final rule is actually promulgated. So employers should review employee classifications. That's a good thing to do on a regular basis anyway, just to make sure that employees have been properly classified. Because it can certainly be significant if a determination is made that they're not properly classified. The overtime owed can be quite large. So that's a good thing for employers to do on a regular basis anyway, is just evaluate employee classifications and ensure that they have been properly classified based primarily on their duties, if they meet that threshold level, to fall into one of those exemptions. This is a good time to identify whether any of the covered employees currently make less than the proposed threshold. You can at least sort of start taking account of how many employees this could actually impact. Start thinking about how you will track hours worked. If a different system will be necessary, if a lot more employees are all of a sudden eligible for overtime, what that system could be. Consider whether it makes sense to raise certain employees' salaries to that new proposed threshold level. Again, it's not actually in effect yet, but these are steps just to take to prepare for that potentially going into effect. And then finally, review policies and procedures that could cover affected employees, and then make sure that you are training employees on the set timekeeping policies and practices. This is another thing that's good to do just anytime, but particularly as there could be significant changes to the amount of employees that might now need to closely track their time, making sure that that training is in place and being done. So we only have a few minutes left, so I'll just go through these last few slides really quickly, but with discussion of both the independent contractor rule and the overtime rule, we just kind of wanted to mention some other issues from a wage and hour perspective that employers should keep in mind. Something that does come up often is this idea of compensable time. So employees need to be paid for all hours worked, and those include hours that they're required to be on duty, on the premises, and it can include wait time, on-call time, travel time, rest breaks, depending on the circumstances. So it's important to make sure that in calculating all hours that an employee's worked, you really have a full understanding of what that means and what that includes. Meal and rest periods. The Fair Labor Standards Act does not require a meal period or a rest break, but it is set law that if an employer offers a rest break, the Fair Labor Standards Act considers that to be compensable time, whereas a meal period, the Act does not consider that to be compensable time as long as the employee is fully relieved of all of their duties during that time. So again, just from the perspective of ensuring that you are calculating all hours worked and properly compensating employees for that time, being aware of how the FLSA treats rest breaks and meal periods. This can definitely vary based on state. All of these wage and hour issues, some states do it really differently. So you do need to make sure that you are also aware of the specific state requirements related to meal and rest periods. And then calculating the regular rate of pay. The regular rate of pay is what needs to be used in determining any overtime owed to an employee. And it can include more than just the set hourly rate that the employee has. The Department of Labor has been specific in what the regular rate of pay includes. And particularly back in 2020, they did speak more specifically to certain perks and benefits and how that can impact the regular rate of pay. I think the most important thing to pull from this is that non-discretionary bonuses are considered part of the regular rate of pay, whereas discretionary bonuses, those that can be related to the quality of work in a year and those performance evaluations, the managers are evaluating the employee. A bonus is not guaranteed when it's discretionary. it's important to sort of be aware of the difference in those in determining the regular rate of pay. And then there are just a few other things here that we wanted to mention, just as kind of, again, things to be aware of from a wage and hour perspective. Wage statements, most states or a lot of states require a wage statement. The Fair Labor Standards Act does not, but the individual states do. So that is an important thing to provide if it's required. A lot of states also set out specific periods in which pay needs to be provided to employees. So that's really important to be aware of as well. And then also record keeping requirements under both the FLSA and state level requirements, just making sure, again, there are specific requirements, but I think the overarching idea here is that particularly for those non-exempt employees, hours need to be tracked, and the employee needs to have certain information provided to the employer that they keep track of related to how the employee is paid. And then again, just sort of some last tips that we have related to wage and hour issues, I think really just generally. We've already talked about the first one, developing a system to track the hours worked. That is essential for your non-exempt employees, and particularly in light of the potential change, you know, in the salary threshold level that could result in a lot more people being eligible for overtime. Avoid interrupting meal and rest breaks. I mentioned that related to particularly, you know, with meal breaks, that the employee is usually not compensated for that time, but if they're interrupted and have to do something during that time, then they should be paid for that time as well. Reimburse workers for reasonable business expenses. And finally, consider revisions to handbooks, policies, trainings, as necessary related to the rules that we've talked about today, as well as just general wage and hour issues, and then auditing wage and hour practices. You know, Kimberly talked about this in reference to auditing your worker classification as either an employee or independent contractor. I mentioned this in evaluating whether someone, you know, is actually properly classified under one of the white collar exemptions. But just general audits also of how hours are tracked, you know, how overtime is paid, what the regular rate of pay is included, you know, things like that to make sure that these wage and hour issues, unfortunately, can be really significant for employers if an employee complains or, you know, the Department of Labor undergoes an investigation. So it's essential to check your practices, check your policies, and make sure they are legally compliant. So that is the end of our webinar today. And then the last couple slides just shows our upcoming webinars. So like I said, this is the first one in our employment webinar series. We have many more to go, lots of interesting topics. We also have several blogs available through our website that we really try to keep up to date and keep you informed. And then we also did want to mention there was a recent rule passed in California regarding workplace violence prevention. And so that's been a real focus of our firm, and making sure that employers have the tools necessary to respond to that new rule out in California. So certainly reach out to us if that's an area that you could use some support. I will check the chat, but we are past the hour, so we won't hold you guys here any longer. If there are any questions that we weren't able to get to today, please, we'll check the chat, but please also just feel free to reach out to either of us. And we really appreciate you spending your time with us here today.
Thank you, everyone.